Now, what is being perceived as a major setback to all political parties, the Supreme Court has struck down the National Judicial Appointments Commission. The Supreme Court has said that the 99th Amendment, which brought in the NJAC, that proposed to give more say to the executive in judicial appointment of judges, is unconstitutional and it violates the basic structure of the Constitution. The commission was created by the government to be an alternative to the existing Collegium system for appointing judges to the highest courts in the country. While the government argues that the Collegium system lacks transparency, the petitioners who were opposed to the NJAC argued that the word quote-unquote eminent as described in the amendment was vague and would also encourage political interference in the judicial appointment. The Supreme Court has rejected the centre's plea that the petition challenging the NJAC Act be referred now to a larger bench, but also said that it was willing to take up suggestions for improving the Collegium system of appointing judges, and also posted the hearing for the same matter for the 3rd of November. Okay, we have with us senior lawyers KT Tulsi and Majid Memon, who joins us. Thank you both for speaking to us on India Today. Mr. KT Tulsi, if I may come to you, I admit I'm not a constitutional expert, but when I was going through the entire verdict, I just wanted to understand that if the Supreme Court has struck down the NJAC, then why is it considering suggestions to improve the existing Collegium system?
Well, they have... They are yet to formulate the revised procedure. They perhaps are trying to bring in some transparency to meet with the criticism of the functioning of the Collegium system, and they want to give it a breath of fresh air or a bit of sunshine by saying that there will be wider consultation with the civil society, or even with the bar leaders or the presidents of various bar associations or bar councils. So this is a process of disinfecting the opaque procedure.
But sir, in a way, isn't the highest court of our country questioning, the Collegium system? Because, it seems that the Supreme Court feels that it too has a lot of flaws that has plagued the Collegium system that has been in existence in the last 2 decades.
There has been, in fact, I think that, personally speaking, the NJAC was an improvement on the Collegium system, and it ought to have been given a chance. But because I believe that the appointment process has nothing to do with the independence of judiciary. Independence of judiciary is guaranteed by the Constitution after appointment, but the process of appointment is outside the scope of judicial independence, because the Constitution very clearly provides for appointment by the President, which means on the basis of advice of the government and in consultation with the Chief Justice and the other judges that it may choose to consult. The process of consultation has been interpreted to mean that no, it amounts to a virtual concurrence, because unless we agree you can't appoint anyone, and if we suggest then you can't refuse. The government has many a times brought out something, but rarely has the court ever accepted the request of the executive to either drop a particular name or have a further look at it. They have been mostly repudiated and reiterated without delay. So I really think that the constitutional balance, which was sought to be restored by the NJAC, has received a setback, but let us hope that there is a genuine introspection with regard to the manner in which the closed door functions, in a closed door the Collegium functions.
Mr. Majid Memon, if I come to you, can the existing Collegium system, ensure transparency in appointing judges? Do you think that the NJAC that has been struck down by the Supreme Court was a good middle ground? It was, a good balance of power between the executive and the judiciary?
See, Avinta, I must tell you one thing. Whether it is Collegium system or it is through commission, which has just been struck down, both the mechanism must have their own, they are having their own flaws. Neither of them is perfect. But then where is lesser evil, where there are lesser possibilities of compromising on the independence and the accountability of the learned judges, who are of course the most important, who play a very important part in the administration of justice of the country by being the highest officers. Now one thing which can be appreciated is this, that independence of judges. What is the meaning of independence? I don't agree fully with my friend Mr. Tulsi that the process of appointment precedes the appointment of the judges, and therefore independence of judges would come into play only after they become judges. This is not correct. We don't want dependent judges to creep in by a flawed system of their selection. So therefore one has to be very careful while selecting judges, that they are judges who would not depend upon either the government or upon anybody else, and would impart justice fearlessly and independently. Therefore, you see, now till now we had this system of collegium where judges were the authorities. Judges did not want anybody to interfere.
Exactly.
Judges say, why
Absolutely.
the government should have its say? We are there, we shall rule ourselves, we shall regulate ourselves, which did not work to the full satisfaction of according to our expectations. For 25 years we have seen there were some flaws. We found that so many judges, sons, daughters and people started coming in as judges. So that also is dangerous.
But sir,
then
there seems to be a divide within the judiciary as
or
well.
Participation in the process must not be such that the judges should be taking back seat. Now one thing very important I wanted to say is this, that in this commission system which we have suggested, Parliament overwhelmingly passed it.
Yes,
there are two
absolutely.
independent persons, and those independent persons are not identified.
Yes.
And there lies, that is the bone of contention. Now the definition of those two eminent persons, has to be clear, because if they are the agents of the government, then the judges will have no say at all. And therefore the majority would mean the Prime Minister, the Law Minister and their two agents. So Chief Justice would be wholly isolated.
But then, sir,
that also, therefore, that is the defect which probably Supreme Court has apprehended.
Okay, Mr. KTS Tulsi, would you like to respond? I just wanted to ask you here that why did the NJAC, that has been overwhelmingly passed in the Parliament, being viewed as being violative of the basic structure of our constitution? Because the NJAC does have the Chief Justice of India. It also has two very senior lawyers of the Supreme Court, including the Law Minister. So isn't it good to have an independent panel who can take a different point of view while appointing judges?
Absolutely. In fact, I think that it was a great improvement on the Collegium system. And I don't agree with this that the eminent persons will become the agents of the government. The agent and eminence, either they are not eminent or they are agents. They are antithetical to each other. They are the opposite poles. And you see, I want to give you an example of Scotland. In Scotland, there is a Judicial Appointment Commission which is entirely consisting of common men, not single eminent person. Why do we need eminent persons? The consumer of justice should have a say in the matter of appointments. They are the ones, and there was a proposal in Scotland that we should have at least the Chief Justice as a member of the Commission. They said no, we want completely, the judges should have no role in the appointment of judges. The consumer, the ordinary people will decide. Why do we go into these eminence and the agent of the government? People have the power to decide who will become the Prime Minister. Why
Yes.
should they also not have a say in the matter as to who should become the judges at various levels? I think that if we want our democracy to be strengthened, which is the greatest and the highest value of the Constitution, then there should be a system by which ordinary people can have a say in the matter, and the occupants can't decide their successors. Nowhere in the world is this system prevalent where the judges will decide who their successors are going to be.
Absolutely. Mr. Memon, do you think the verdict, set up a potential confrontation, between the executive and between the politicians? Because as you rightly said, it got an overwhelming majority. It was passed by both houses of the parliament. But don't you think that the fight between the executive and the judiciary
not overwhelming?
It was absolute. It was passed.
It's a law which was passed unanimously.
Absolutely. Absolutely.
No.
It was
unanimously
a law that was
in both houses.
True. So, Mr. Memon, don't you think that the fight...
I must clear... I will see, if you look at it from this angle,
yes,
let us have, we should not be prejudging issues.
Absolutely.
Now, how has this commission come into being? Because there is an overwhelming will of the people through parliament, and almost all political parties supported, and therefore if you look at it from the democratic principle, you would certainly feel that the will of the people must prevail, and the parliament, being the supreme lawmaking body, must have its say. True.
And that's probably what, that's probably why so many politicians...
At the same time, as I said...
Yes. I was saying that that's probably why so many politicians and political parties, including the law minister, were surprised by this verdict.
I would, in this discussion, I am discussing this matter not as a politician or as a member of parliament. I am discussing it as a person, as an officer of the court, as a man who belongs to the law fraternity. And therefore I would say that judges must have an upper hand, or judges must have a final say. To that extent I agree on the appointment. But judges must not have absolute say, which is unfortunately again causing some disturbance, and therefore today even a common man has the courage to say that the judges are corrupt or the judges are not impartial. You see, therefore we will have to improve the image of administration of justice. This system of Collegium, which has been in operation for 25 years, has not enhanced the glory, the majesty, the faith and the confidence of the people as far as the judges are concerned. So I think we need some changes. Let us not have a collision between the executive and the legislature and the judiciary or any organ of the state. Let us go back, and I think the parliament also could reconsider, instead of striking down the entire commission. It would have been better had Supreme Court made certain suggestions and had sent it back to the parliament. I think that would have been a better course for the highest court.
Mr. KTS Tulsi, if I can come to you, do you think that today's ruling underscores, the need for some much needed constitutional reforms? I'm not questioning the verdict, I'm just asking you.
It does. That's right. I think it does require reform. And to me, independence of judiciary and accountability of judiciary, both are equally important. How can the judiciary explain the delay of 10 years, 15 years, 20 years in the disposal of cases? People who are sitting in jail, they have practically served the entire sentence, and yet their matters are not heard. The ultimate verdict of guilt or innocence is not rendered. Now, there has to be an accountability. Every public institution is accountable. It can't be that judiciary is accountable to none. Independence, in the name of independence, we can't say that judiciary is completely out of the realm of accountability. Every institution must, we should have performance index of the judges, which should be put on the website. That will enhance the efficiency of our institution. The judges who are not deciding at various levels, they need to be weeded out.
Absolutely. Mr. KTS Tulsi and Mr. Majid Memon, thank you both. Gentlemen, such a pleasure to speak to both of you on the verdict that came about earlier in this morning, where the Supreme Court, rejected and declared the NJAC to be unconstitutional and void.